two courses into one, where we're going to kind of take information from chapter 12 that is going to be relevant to what we're talking about in chapter 15, which relates to next week's presentation, which is the final presentation, all right? First of all, as I shared with a couple of people, I got an email today from one of your classmates, Miss Latney, who says she was on her way to the hospital. And so I called her, and sure enough, she was not joking. She was in labor. Of course, I knew she wasn't, joking, but just wanted to give her, our very best wishes for her her speedy delivery and safe delivery. And I offered her extra credit points if she chose to name the child in a little middle name, But we certainly are rooting for her, and hopefully, you may find out shortly that she's had the baby. But we bought some cake in her honor from an event we attended earlier, and so we're grateful for the American Petroleum Institute for their generosity on their cake. So we are going to again quickly go over the key issues here, and I'm sure you guys have already again been on this because it was assigned to you as homework. So we'll just kind of go over some of the things that you already talked about. So start off, and okay, so we've talked about the what happens. We talked about in the past the whole idea of the grievance process, right? And we talked about, as you may remember in the chart, at certain points the parties might reach an impasse in terms of the actual resolution of a grievance. And so there are three ways of resolving a grievance. In terms of getting a outside party. What are the three ways of resolving a grievance, Ms. Champon? What's mediation? One. Mediation. Fact-finding and arbitration. All right. And in most negotiations between labor unions and employers, there must be an agreement before a third party is brought on. So that's the exception is, again, in national emergency disputes. And under the Taft-Hartley Act, there's an obligation for a mediator or arbitrator to come in that case. Now, what is the difference, Ms. Champon, between a mediation and arbitration?
Mediation is a third party that tries to assist the parties to reach an agreement, and then an arbitration deals with there's two types of arbitration, which is the interest and the rights arbitration, but it's pretty much like a form of mediation and fact-finding.
Kind of, but there's a key issue that you again are needing to understand, and this is very important. Thank you, Mr. Ave. Key difference between mediation and arbitration.
Arbitration seeks to make a final ruling on the issue at hand, rather than mediation is just bringing parties to the table to discuss it.
Absolutely. arbitrations are oftentimes, you have to leave?
Yes, sir.
And why are you leaving?
You have a basketball game?
You have a basketball game. What is your role in that?
Manager.
You're the manager of the basketball team?
Yes, sir.
Okay,
You
awesome.
know
What,
what I believe.
hold on. We got 2 people leaving?
I had to go.
You got to go too?
Yeah.
Where are the excuses from, you have any written team excuses from?
Yeah, I'm gonna bring it to you.
Bring it to us, okay. You don't have
I
one?
can ask my coach too.
Of course, the coaches have to give you one, you know. Where is the game going to be played, actually?
In the gym.
In the
Oh, in the gym?
Yes, sir.
What time does the game start?
7.
7 o'clock?
Yes, sir.
All right. Well, we'll look forward to those excuses. And good luck, or not good luck, but much success. Much success. So, in the context of the conversation at hand, arbitration is key, understand. Now, there's some arbitration, again, in which the parties are going to be bound. So again, some arbitrations don't, again, bind the parties to the decisions. The key issues, again, as Mr. Abe said, a decision is reached in arbitration. In a mediation, the parties are encouraged to reach a decision. But in an arbitration, the arbitrator serves almost as a judge, right? And again, there's 2 types of arbitration. One is binding and one is non-binding. In many cases, in context of labor or disputes or arbitrations of labor union disputes, those arbitrations are going to be binding. That means that whatever the arbitrator says is basically what the law is. And the only, again, option after that, in some cases, is to basically file a lawsuit, all right? But there are other mechanisms as well that we're going to be going over, all right? You guys can have a seat, thank you. And so the key that we're going to talk about, again, from the context of arbitration is, because the arbitration is really what you're going to be going over in next week's presentation, involve what? What is an arbitration? Now, one of your classmates mentioned the 2 types of arbitration. Mr. Mason, what are the 2 types of arbitration that was mentioned in the book?
The 2 types of arbitration is interest arbitration and rights arbitration.
And so, what is interest arbitration?
Interest arbitration deals with situations in which the parties have an interest in the terms of the agreements because the contract will specify future rights.
Now, rights arbitration.
Rights arbitration involves the interpretation of an existing contract to determine which party is entitled to a certain outcome or to take a certain action.
So, can you give me an example? If there's an example in the book, you can use that as well.
For interest arbitration, interest arbitration was used by the National War and Labor Board during World War II and has been imposed on railroads by Congress on a number of occasions since the 1960s. Interest arbitration is offered by the NMB in impasses before the parties are released to engage in self-help, which is strikes and lockouts.
525.
Thank you. So, for your exercise next week, you will be engaging in a mock interest arbitration. You all will have, again, a role in to play in a mock interest arbitration. So that's the reason why this idea of arbitration and interest arbitration is so important. Now, what's the key characteristic about why we're using an interest arbitration relating to the adjunct professors? Where are interest arbitrations used more so?
In the public sector.
In the public sector. And what does that relate to what we're doing?
Is it because public university?
Because Bowie State is a what?
Public university.
Is a public university. All right. So that's a key issue to understand. All right, you can have a seat. Now, if, for example, again, we have a so again, the key issue here, just so we can have a clear understanding, is that most times interest arbitrations are arbitrations based upon, again, the contract being renegotiated. So for a new term, we're talking about, again, after the term has already expired, right? Versus, again, the interpretation of what a term means under a current contract. So that's the key issue to understand, all right? Second of all, now I want to go over with you because, again, if the arbitration is not utilized, for example, or if there is another mechanism that, again, results in an impasse, another situation results in an impasse, you will need to know about strikes. So in that context, we're going to quickly go over this and ask Ms. Mathis, tell me, what are the 4 major types of strikes?
Economic strike, unfair labor practice strikes, wildcat strike, and sympathy strike.
Okay, she said first, economic strike. Second is the unfair labor practice strike. Third is a wildcat strike. And lastly is a sympathy strikes. Now, what is the major thing that these 4 types of strike have in common?
Employees refuse to work.
Employees refuse to work. Now, before we go into the details about what economic strike is, tell me, what's the opposite, Ms. Mathis, of a strike? What is it that the employer does or can do if there's an impasse? The opposite of the strike that, again, the employer uses. Mr. Fitzgerald, you want to help her out?
A lockout? Would that be?
I think it's a term to shut down.
Shut down.
What is it, Mr. Fitzgerald?
It's a,
Shutdowns?
Shutdowns and what? You said it earlier.
Oh, lockout?
Lockouts. In fact, what does it say on page 437 specifically?
Okay.
Thank you.
Lockouts are the flip side of the strike coin. Employers use them most frequently when faced with strikes involving perishable goods or multi-employer bargaining units.
Now, why, either of you, why is the lockout used more so with perishable goods, Mr. Fitzgerald?
Oh, well, So I guess an employer dealing with perishable goods is frequently at the mercy of the union. This would be. Can you repeat the question?
Ms. Mathis?
Because a strike would impact, the impact would have caused the breeze to rise, so the food to rise.
That's right. So if I'm selling strawberries, right? I'm selling grapes, strawberries, other goods like that, right? That basically perish, overnight in some cases, if they're not basically picked and put into the refrigeration. If my union workers basically say, well, we're going to stop work, right? Then, or we get to an impasse, even before they say they're going to strike, then I might have to say, okay, well, look, if we can't reach an agreement, we can't, continue to debate this issue. We got to get this product produced, right? So I'm going to basically bar all of you all from coming in. You can't come to work. And I'm going to bring on some other workers who are going to make sure that this produce gets to market, right? That's the opposite end, all right? What's the other one, Mr. Fitzgerald? The other reason why employers will opt for a lockout?
Multi-employer bargaining units.
So tell me about that.
As discussed, several small employers that are engaged in the same business and whose employees are represented by the same union often form a multi-employer bargaining union. But if the union strikes only one employer and attempts to break the solidarity of the group by using a whipsaw strategy, can the remainder of the employers lock out their employees? Can we keep going?
Mm-hmm.
When one member of the multi-employer unit is struck and the remaining members lock out their employees, the lockout is defensive in nature, and without its use, the continued integrity of the bargaining union could not be ensured. Multi-employer groups can also lock out employees when one is struck and temporarily replace them for the duration of the lockout to continue operation.
What's an example between a multi-employer group? What's an example of a multi-employer group that had a lockout? What is it? Right. Then a multi-employer group? You got multiple employers, right?
Mm-hmm.
How many employers? 30 different teams, right? And again, the strike wasn't just in terms of one team, right? It was the entire league, right?
Mm-hmm.
And so therefore there was a need for, again, not just a lockout of one team, but all the teams, right? Now, it might be argued that the employer is not the team. It could be argued that the employer is who? Ms. Mathis? The employer.
The employer? Isn't it the, somehow for the lockout, right?
Right, in the context of this conversation. Who could the employer, who could it be argued that the true employer is? And it might be actually the case. I don't know NFL contracts, but it could. The league. The league itself may in fact be the employer, as opposed to the individual teams, right? The contract, I don't know if anybody has seen a contract, an NFL contract, player contract. The contract could be, again, between the league and the player, as opposed to the team and the player. You guys don't know.
It's a little bit of both.
And it's possible that both have rights, right? But this, assuming that it's between the teams, this would be an example of a multi-employer lockout. what happens in a single employer negotiation before we leave this topic? Ms. Mathis.
In a single employer negotiation, there's no need to defend against a whipsaw. Thus, the question of whether a lockout interferes with employee rights to engage in concentrated activities.
Concerted
Activities must be scrutinized more closely, unless an
impasse
occurs, a lockout cannot be implemented.
So again, the reason why the law allows for a multi-employer and the multi-employers who are represented by the same union to engage in a lockout is because sometimes what will happen is that one group will strike one employer as opposed to striking all of the employers in order to break up the solidarity of that group, right? So they can reach a decision, reach an agreement with one employer that again is at the mercy of that one union. And so in order to prevent that from happening, then all of the employers in that group will lock out the employees, again, as we discussed about the NFL player lockout. However, a single employer can't lock out. So it can't have a lockout because there's no threat. So again, in a single employer negotiation, they don't have to defend against this whipsaw impact. So when you do so, again, outside of the perishable goods industry, then you have to be very careful that you're not in violation of the law. Okay, that's the key issue. All right, you guys can have a seat. Now, let's go back to strikes. Again, going over those 4 areas of strikes, and that was Mr. Fitzgerald. That was Ms. Mr. Mason earlier, and Ms. Mathis. Okay, Ms. Olatunji, now tell me, what are the forms of strikes? Mm-hmm. We talked about them. We talked about the 4 types of strikes. What were they? Ms. Olatunji.
Wildcat strike.
That was one.
Unfair labor practice.
Mm-hmm. That's 2.
Second strike.
Mm-hmm.
And the economic strike.
Economic strike, all right. But tell me about the economic strike.
It's called after a contract expires, and usually after there is an impasse.
An impasse.
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 I call it too,
Impasse.
Impasse. Everybody say it. Impasse. Impasse means what, Miss Olatunji? It means to pass something?
To not pass.
To not pass something.
Yes.
So that's, what does that mean in layman's terms?
540.
Thank you. When you reach a impasse, not impasse, but you reach an impasse, what does that mean?
You can't reach an agreement.
You can't reach a deal, right? You can't reach a deal, right? So again, it's called 1, after what? The contract is expired, 1. And 2, when what?
Pressure the employer to settle on the union terms.
Mm-hmm.
The union believes the strike's costs, both economic and political, will be less to it than to the employer, and that the benefits to the union will, from achieving its demands are greater than the strike's cost. An economic strike can be called over any mandatory bargaining issues, but if the union goes to impasse over a permissive issue, it commits an unfair labor practice.
And again, the difference between a mandatory issue and a permissive issue is what?
It commits an unfair labor. It commits an unfair labor practice.
The difference between a permissive versus mandatory, and you should make note of this because it's likely to be on your exam, is what? From earlier, Ms. Poe. The difference between a permissive versus a mandatory bargaining issue. Ms. Poe. I know you know. And if you don't know, I'm sure you can find out.
Permissive and mandatory?
Exactly.
Mandatory is you have to.
Or you, Ms. Olatunji. I'm sure you can find out, right?
Can I go?
What's the difference?
No, okay,
So you want to know the difference between mandatory and permissive?
Yes, go ahead, Ms. Washington. Bring it home.
Oh, okay, okay. So, the mandatory bargaining issue is an issue that is, voluntarily required to be discussed if one of the parties in bargaining raises it, and then the other one, what was the other one?
So the mandatory is again, mandatory, again, is what again?
Mandatory, what was that word? I can't read it. It's an issue that is, you see the word, the S word?
Mandatory bargaining issue.
No, you can't do that. No, let me do this. You don't do it today. It's an issue.
You can help her out because you don't know the word.
Just say the S word. That's it.
Bargaining.
No. Go ahead. What were you saying about the mandatory?
Mandatory bargaining issues deal with wages, hours, and other terms and conditions of employment. And permissive bargaining do not require a response because they have no direct impact on management or labor costs.
Now, Ms. Washington, the word you were looking for, you were trying to say is what?
The S word.
Well, why are you sitting down, Ms. Washington? You still
She
talking?
didn't want me to go.
That's okay. You were going, but you missed the word. What was the word? The S word.
No, I won't do it. Hold on, I got it.
Stat.
I said that. I said stat and then.
Stat what? Statutorily. Statutorily. What does statutorily mean, Ms. Washington? What does that mean, Ms. Poe? Statutorily. What does that mean? A bargaining term that's statutorily required.
By law.
What's that again?
By law.
By law. What are terms that are statutorily required in every contract? Ms. Poe? What are terms that are statutorily required in every contract? An employment contract.
An agreement?
So, Olatunji?
Well, that was nice. I said an agreement. But
Ms. Washington? Terms, think about it. You work for a week.
Unless you have to come to work on time and things of that nature.
Again, time, you said maybe, is it statutorily? Is there some law that requires you to come to work at a specific time?
I mean, if I sign the contract, I do.
No, I'm not saying
Okay.
the contract. Okay, because you can be bound by the contract under law. But I'm saying, what are employers obligated to do under law for every employee. Coming back to
You have to pay us.
Ah! No.
They volunteer work.
Pay.
Oh my God.
Pay, right, is a what? Is it permissive?
It's mandatory.
It's a mandatory. Mandatory. Again, go back over that list of mandatory terms, Ms. Poe.
Wages, hours. and-
Wages,
Hours,
hours,
and other terms and conditions.
and other terms that are, again, statutorily required. All right? That's the key difference. And those, again, those are things, can they be, again, and an economic strike, a strike can be called at what time, again, related to those mandatory? It can be called at what time? Involving a mandatory issue, it can be called at what time? At any time, right? So if we got an impasse, if there's a dispute over how much you're going to pay me, we can't work, right? We can't work. If there's an issue over how many hours that I have to work, right? Can we work? We can't work, right? So again, those are the types of things. If there's an issue over my health and safety on the workplace, right? Then what? I can't go to work, right? So that's what? Mandatory. Mandatory. All right. You guys can have a seat. Who was telling me about the different types of strikes, though? Is that you, Ms. Olton? What's the next one?
Unfair labor practice strike.
Tell me about that.
Protest employer labor law violation. If an employer violates the law, the employee's right to strike and protest and to be reinstated and is absolutely protected by the NLRB, National Labor Relations Board.
Outstanding, Ms. Olton.
In the courts.
All right. What's the next one?
A wildcat strike. And it's an unauthorized stoppage during the contract. Employees must be disciplined if the strike breaches a no-strike clause. And next is a sympathy strike. It occurs when one union strikes to support another union strike. Such strikes occur where more than one union represents employees in a single establishment or where several plants have separate contracts.
Excellent. And what's the key thing before any strike takes place? What has to happen, Ms. Olatunji?
Employees refusing to work.
Before that happens, what has to happen within that union?
Strike votes and going out.
A strike vote, exactly. The union leadership must come to the members and say, members, do you all want to strike or do you all want to stay on the job? The leadership can't make that decision on its own. Okay, key point. All right? Okay, you can have a seat, Miss. That was Miss Poe. And that was Miss Tunji. And Ms. Washington, right? Okay, all right. Now, what time is it?
5:50.
Okay, great. So we want to talk about now going to chapter 15. The, again, arbitration process, right? We talked about what an interest arbitration process is, but what is the steps? How does the arbitration process, again, going to chapter 15, how does it work? What are the steps? And this, again, is what you're going to be, again, simulating in the next presentation, an arbitration. So what are the steps of that arbitration? First, what's the first step of the arbitration? Arbitration procedures. Tell me, Miss.
Pre-arbitration matters.
Somebody just come in the room, all right. Go ahead for him, Mr. Scott.
We have pre-arbitration matters.
Tell me about it.
The contract specifies how an unresolved dispute goes to arbitration. Normally, arbitration is used for cases the parties have been unable to settle in one of the preceding steps of the process. If management denies a grievance at the last step or fails to modify its position sufficiently for the union to agree, the union can demand arbitration.
Okay, so we're going to go over the arbitration procedures. Again, you talked about the pre-arbitration, right?
Right.
So what are the rules, first of all? What are the rules concerning the arbitration? Where is that found? Where's that found?
In the
Mr. Scott?
pre-hearing?
No. What are the rules for how the arbitration is going to be conducted? Where's that found?
The Collier Doctrine. No?
What are the rules, or where are the rules for how your arbitration is going to take place?
What are the rules to how the arbitration is going to take place?
It's contained on the page concerning arbitration procedures. Where are you going to find? Who can tell me? Anybody? Where are you going to find the rules concerning how your arbitration is going to take place? Or even the pre-arbitration procedures? Where are you going to find those rules? What is going to govern how the arbitration is going to take place? What's going to govern how you're going to select the arbitrator? What's going to govern how much time you have to submit your issue for arbitration? What is going to govern that? Ms. Pope? Ms. Pope? We're having a conversation, are we not?
Yes.
Why are you sitting down?
Where are we going to find the rules and procedures?
Where I'm the union, where am I going to point to?
Supreme Court.
What? Ms. Mathis, bring it home. Huh? I'm going to point to the Steelworkers Trilogy and say, hey, the Steelworkers did this. What year was the Steelworkers Trilogy? Huh? Ms. Mathis?
Hold up.
What year? What year was the Steelworkers Trilogy? When was it? When was the Steelworkers disputes? When was that? You mentioned it.
555.
Thank you. When was it? You gonna mention something you don't even know the year?
1960.
In 1960. And so what was it? Since you mentioned it.
It protects a union's right to insist on arbitration.
The Steelworkers Trilogy cases? Is that what it is?
No, Steelworkers Trilogy.
What is it?
It protects a union's right to insist on
arbitration and to have a more support for our community.
You're telling me that the Steelworkers trilogy, when you say a trilogy, what does that mean?
What's the rules? She said, where we gonna find the rules?
He asked me about that trilogy.
Oh, the trilogy, decisions enable arbitrators.
There is some Supreme Court decisions, right?
Yeah.
And in the Supreme Court ruled that arbitrated decisions were what? It was the final decision-making step. So again, that means that they were not subjected to what? They were not subject to what? If you didn't like the arbitrator's decision, then what? Ms. Pope?
Then
If you didn't like the arbitrator's decision, then what?
select a new
Mr.
arbitrator.
Huh?
Select a new arbitrator.
If you did not like the arbitrator's decision, then what, Mr. Scott? Ms. Mathis? If you did not like the arbitrator's decision, then what? If you did not like the arbitrator's decision, then what, Ms. Pope?
The Supreme Court ruled that arbitrators' decisions were essentially not subject to judicial review.
And what does that mean?
It laid down three basic protections for arbitration.
No, I'm asking you, what does that mean? What does it mean when it says not subject to judicial review?
They're not able to go to court.
Huh?
They can't go to court.
They can't go to court. So if you don't like the arbitrator's decision, then what?
Find a new
If I rule against you, then what can you do? Ms. Mathis? The trilogy, which you said, and thank you for bringing it up because I wasn't going to go too deep into it, but might as well. Now that you brought it up, Supreme Court Steelworkers cases, right? They came up with three basic protections for arbitration, right? The contractual arbitration clause requires that parties arbitrate unresolved grievances. The substance of grievances and their arbitrability are to be determined by arbitrators, not courts. And if an arbitration clause exists, unless the dispute is clearly outside the contract provisions, courts will order arbitration. So again, if the unions or if the employer does not like the decision of the arbitrator, then what? Mr. Scott. Then what? The answer of the word, the first, it's a two-word answer. Two-word answer. The first word starts with T, and the second word starts with a B.
Too bad.
Too bad! Too bad! Too bad!
Arbitration the last step.
That's right! Not subject to judicial review. That means that you can't go to court. Thank you. If you don't like the decision,
said something.
So you, not me. Because the arbitrator's already given us the ruling. Right? That's the key to this. And again, thank you for bringing it up.
Now, if you were to go, let's say the arbitrator made a ruling and you didn't like it, you would strike anyway till they file a lawsuit.
And the answer to that is to the answer is included in the Norris-LaGuardia Act. And what does the Norris-LaGuardia Act say? Since you've raised it, Mr. Ave? Mr. Ave?
It says it forbids lawful union activity. Forbids court from enjoining lawful union activity.
So again, it forbids the lawful union activity. However, again, a strike after an arbitration, it would be what? Would be unlawful. It would be unlawful. Okay? So again, that's the key issue relating to that. However, she did not answer our question. You can have, you guys, you came up in this conversation with, it was you two? Oh, no. It wasn't you. Okay, you can have a seat. You just said, and you can have a seat. No, you're still standing. So again, where are the rules? That was the question I said. Who was that? That wasn't your question? No. I bet you came to that question. Where are the rules for the actual arbitration? And then your colleague came up and said the rules were contained in the Supreme Court decisions called the trilogy, the Iron Workers Trilogy, right? That's what you said. Steel Workers Trilogy, right? And we know that was absolutely not the answer.
So
but the rules, if I want to go to find out, one, how I'm going to find my arbitrator, two, what time must I bring this matter to the arbitrator, right?
A permanent umpire? To go to them?
That's a person.
The American Arbitration.
It's found on that page that we were just reviewing. No. It's found on page 516 under arbitration procedures. Hint. No, don't try to raise your hand now. Don't try to raise your hand now, Ms. Mathis. You had your turn. Huh?
It's in the contract.
Mr. Scott, tell me about that.
Hold on, wait. No. Swap it out. Hey, swap. But it's where it's down. He said, selection of an arbitrator. 516.
Read, Ms. Pope.
Procedures for selecting an arbitrator are specified in the contract.
Thank you. What does it say under pre-arbitration matters?
The contract specifies how an unresolved dispute goes to arbitration.
All right. So again, if you are going to do some arbitration, arbitration has to be in your contract, right? So that's the first thing that you guys are going to be, again, looking to is, again, what does the contract say? Start one. Thank you. Okay. All right. Now tell me, what are the sources and qualifications of arbitrators now? Since you guys didn't necessarily get that one, but give me this one. What are the sources of arbitrators? 3 sources of arbitrators. 1, Ms. Pope.
National Academy of Arbitrators.
National Academy of Arbitrators, all right? 2nd, Mr. Scott.
American Arbitration Association.
American Arbitration Association. 3, Ms. Pope. All right. And so generally these organizations are going to contain a list of arbitrators, right? Generally the way it's going to work is that they will say that, again, in the contract will say that we're going to use one of these groups. That's what the contract will generally say, right? And maybe they say the American Arbitration Association, which is one of the most common. And I've had a case that was arbitrated with them. And so what's going to happen is that they're going to send you a list of names of possible arbitrators, right? And you have to look on the list and see which one you want and which ones you don't want. And so generally, you're going to look for those, if you're a union representative, you're going to look for those people who in their background have some bias against unions, because you don't going to say, I don't want them. If you're a business person, you're also going to look for, again, those people on that list who may have a bias in favor of unions, because you're going to say what, Ms. Poe? If you're a business or an employer, and you see, again, names on this list of arbitrators, and you go and do some research, and you see that some of them have taught labor relations law, and in their teaching of labor relations law, they happen to seem at least somewhat disposed or predisposed to the side of the unions. And what might you say? What might you say?
You said if it was a business and
if I'm an employer,
right,
and I see that there's an outstanding professor teaching business law, labor relations law,
right,
and he seems to be somewhat predisposed or biased towards labor unions,
right,
what am I going to say if I'm an employer and I'm selecting, again, those people?
Well, I'd work with them, right?
Huh?
Work with them or against them?
Or work against them if he for the union.
Okay.
What might I say, Ms. Poe?
Work against them.
So again, I got a list of names on this. They submitted me a list of names.
Right.
I do the research, and then that list, I determine that somebody, that I'm an employer, I determine that somebody may be biased against, again, may be biased towards union. What am I going to say, Ms. Poe, if you're the employer?
You the employee and they like unions, you wouldn't want it. Yeah. You only want them to like unions if you're a part of the union.
So if you're biased and you see somebody's name on that list who might be biased, what are you going to say?
That's not right.
And what do you want to do?
She don't want you. She being fair.
Huh?
She don't want you.
What might you say, Ms. Poe?
We don't want.
Yes, we don't want this person. Strike him, strike her from this list. No, right? I don't want this person. I don't want that person. This person is good. This person is good. You see that? So that's what's going to happen. You're going to get names. The other side's going to get names. And then they're going to look at which names were both circled, right? And which ones were stricken. The ones that were stricken go off the list. The ones that were circled in common, right? Or if they weren't in common, but they were both circled, then they, again, then they weren't strict. That means that, hey, they can both, possible one that both sides have agreed upon. All right? That's the way that's going to work. All right? So that's the first thing.
610.
Thank you. Second thing is tell me about the pre-hearing process. So hopefully one of you guys get this right and you can sit down. Tell me about the pre-hearing process. What is the pre-hearing?
There's about 10 steps.
Tell me the step. Let's just go through the for here. What's going to happen?
Review the history of the case as developed at the Article 7 of the grievance procedure.
All right, let's go to the second one, Mr. Scott. What's the
That's
second?
the entire collective agreement to ascertain all clauses bearing directly or indirectly on the dispute. Also compare current provisions with those contained in prior agreements to reveal changes significant to the case.
And in this example, you guys are going to have a contract. You're going to use the clause in the union's agreement with the university. ASME's agreement with the university, that's going to spell out, again, the clause, the arbitration clause, all right? And you're going to, and again, we're going to identify, I'm going to single out which issue is going to be up for dispute. And so that's the one you're going to focus on. C, what's next for you?
As to determine the general authority of the arbitrator and accordingly the scope of the arbitration and examine the instruments used to initiate the arbitration.
So the instruments means what, Ms. Paul?
The components that make up
The instruments. What do you think an instrument might be? What's a legal instrument?
a legal instrument.
A contract might be a legal instrument, right? That's a good point. A contract might be a legal instrument. Again, but in this instance, the legal instrument that is the jump starter, if you will, for the arbitration is going to be a request for arbitration. That's generally what they're going to be looking for. So you're going to look at the terms of that. What is the person saying is the issue, right? That's why you want to look at that. All right, next, Mr. Scott.
Talk to all persons who might be able to aid development of a full picture of the case, including different viewpoints. You will thus better understand and know not only your own case, but your opponent's as well. If you can anticipate your opponent's case, you can better prepare to rebut it.
Exactly. And so again, you're going to have witnesses. Each team is going to have a witness. All right? You can have lawyers, and you can have witnesses, right? And the team is going to have to present its witnesses. Well, first you're going to have some interviews with these witnesses. So in this context, you will have to interview some professors, right? And the other side is going to have to interview some administrators, right? To determine the strength of their case. Next, Ms. Poe.
Interview each of your own witnesses. A, to determine what they know about the case. B, to make certain they understand the relation of their testimony to the whole case. C, to cross-examine them to check their testimony and to acquaint them with the process of cross-examination. Make a written summary of the expected testimony of each witness. This can be reviewed when the witness testifies to ensure that no important points are overlooked. Some parties outline in advance the questions asked.
And so that's key. Because the way in which that's going to happen is that, again, you're going to have the lawyers that are going to be representing, again, each side. The lawyers on one side are going to introduce themselves, going to say what the key issue is relating to the clause that they favor, or the interpretation that they favor, right? And then they're going to introduce their witness. And they're going to say, well, what my witness is going to basically testify to. And they will know what their witness is going to testify to because they have done what? They have done what? Huh? They have done what? Huh? They have done what you just said.
Interview.
They've written a summary, right? They've written a summary, right? But they've also done what? Interviewed them. And in fact, because they've interviewed them, they will actually be drafting the testimony. So oftentimes the lawyers draft the testimony. They interview, so you told me this. Okay, I've written this down. Ms. Poe, you said this, right? Review this. Is there anything in what you said, what I wrote, based upon what you said, that's in dispute with what you know? Right? If there is a dispute, then let's change it right now. Because when you go up there before the arbitrator, I want to make sure that we have, no surprises, right? I want you to tell them exactly what you told me. And to help you out, here you go. This is a written summary of what you told me. All right? So, but then on the other side, again, when Ms. Poe, when I ask my questions to Ms. Poe, right? I'm her lawyer. I say, Ms. Poe, what happened? What are the issues that you find? What? Why are you, concerned about this? Going down the list. Then the other side, the lawyer from the other side, is going to do what? Mr. Scott? You said it.
Going to do the same thing on his side.
But before that, you used the word. Starts with a C. Do you remember? Or was that Miss Poe? Did you use that? In item C, under subsection C, under item E. What was that, Mr. Scott? Cross-examine. What does that mean, Ms. Poe? So I've asked you, I'm your lawyer. I've asked you questions based upon what I drafted for you based on what you told me, right? Then what's next? Cross-examine, and what does that mean? Cross-examine, Mr. Scott, is what?
That's my evidence with yours.
What I'm going to do, what you're going to do, you're the union now. She's the employer. Her witness has testified, and so you're the lawyer, and you're going to do what?
Cross-examine.
Cross-examine, that means what?
Make sure that what she's saying is actually what it was.
You're going to try to poke holes.
In her story.
In her story.
Right.
You're going to try to poke holes in her story. That's what cross-examination is.
Okay.
Oh, Ms. Poe, you said that the people, again, in the union want to work at this time.
Right.
But why did you have a sign saying that you all would prefer to work at this time? Again, questions that would be deemed as, again, contradictory, right? To show contradictions in your testimony. That's what a cross-examination is going to do, okay? All right? So next, what do we have there, Ms. Poe? Mr. Scott, next.
Examine all records and documents that might be relevant to the case. Organize those you expect to use and make copies for use by the arbitrator and the other party at the hearing. If needed, documents are in the exclusive possession of the other party. Ask that they be made available before or at the hearing.
And this is key, because these documents are going to be used as exhibits. You're going to say, Mr. Arbitrator or panel of arbitrators, I want to introduce into evidence what is marked as Exhibit A. And you're going to say, in fact, and again, in the court, it's somewhat different from in arbitration, but they use some of the same things, so it doesn't have to be exactly according to the rules of civil procedure, which is what, again, courts operate based upon, but it's kind of a modified version of those rules. And so, again, exhibits will be, again, used to provide foundation for the arbitrator to make their decision. So they're going to say, again, you have, several possible exhibits. One might be the contract, right? One might be, again, in this instance, a flyer that contradicts their point. So I want to present to you, again, Exhibit A. And then you're going to talk about what Exhibit A is. You might ask her questions based upon Exhibit A. It might be Exhibit B, Exhibit C. So that's what you all will have to do. Come up with exhibits. I'm going to give you guys a fact pattern, but the exhibits will be what you have to come up based upon that fact pattern, all right? Ms. Poe.
Visit the physical premises involved in disputes, visualize better what occurred and what the dispute is about. Also consider the advisability of asking at the hearing that the arbitrator also visits the site of the.
Exactly. So this is an issue about, basically the smell or the, let's say, temperature. If the building was really cold, and sometimes the building does get cold. Thank you. If you want to basically get the arbitrator to really understand, say, Mr. Arbitrator, can you come and check out, again, the facility? You'll see firsthand. All right? we're not going to go through the entire thing, but these are the things that you're going to have to follow, again, in order to prepare for this presentation for the next class. We're going to have, what we're going to probably do again is, because what we may do is we're going to probably divide up, like one group will probably be the lawyers, and then we're going to probably have one group as the witnesses. And then the other side is going to be the lawyers for the, so one group is going to just be the group of witnesses. We're going to identify, be the witnesses for the, for one team will be the witnesses for the, so there's two ways we're going to probably think about it. I'm trying to determine right now. You'll know though, before the next class, is whether we'll have one group as this be the witnesses, or one group as the judges or the arbitrators. And I'm inclined to do that, and then invite somebody else to help out with that, to be a guest arbitrator. All right. So that's the procedure for the next presentation. We will again send that out this week, so you'll be able to prepare for next week, since it's your final presentation, and we'll go over it from that. And in fact, the majority of the class, the next class, will be basically the presentation, because it'll take up almost the entire class. All right, and we'll probably go over the next class will be the, what's the next class? What date? 6. Right. So that will be the last class, because the next class will be the final exam. All right. Okay. So let's have a break. We'll come back and do the presentation.
That's cool.